let's let's talk to John Kavanagh. Let's have a conversation with John Kavanagh. Yeah, I thought I had this thing all set up nice before I got on. I guess I didn't, but let's have a nice conversation with John real quick. So, where is John? Does anybody know where John is? I'd like to know where John is. I'm a member of the press. What I do is I hold public officials accountable by auditing our rights. I have a right to understand what public officials are doing, and so that's the reason why I want to interview John Kavanagh. Does anybody know where John Kavanagh is? Does anybody know where John Kavanagh is? How you guys doing? Does anybody know where John is? Or does anybody know John's schedule? I'd like to ask you some questions, John. I'd like to, because this has been the problem with America since the beginning, is everything is done in the dark and we don't get to know what's happening before it happens. If you had known that Atwater versus City of Lago Vista, if you had known that in 2001, there's a Supreme Court case that says you can get arrested for any infraction of the law. I believe that if you knew that, you would have protested in the streets the next day. If we all knew collectively together, I'm just going to run down a couple things here for you guys real fast. If we all knew collectively that we're going to fundamentally lose our rights, let me give you guys a real quick rundown. And this is why I want to interview John Kavanagh. If anybody knows where John is, I'd like to talk to John Kavanagh. I'd like to have a conversation with you, John. I'm the member of the press. I hold public officials accountable, Mr. Kavanagh. I'd like to have a conversation with you. I'd like to know why there's a cop of 20 years writing legislation that's pro-cops, pro-thin blue line. John Kavanagh, I'm a member of the press. I'm nonviolent. I'd like to have a conversation with you, sir. I'd like to have a conversation face to face. I'd like you to answer some questions on camera as to why you're writing legislation that would make it impossible to film cops at the proper distance to see if they're violating someone's civil liberties, sir. I'd like to have that conversation with you, Mr. Kavanagh. That's why I'm going to crowdsource this. Anybody watching this, I'm looking to have a conversation with John Kavanagh, this gentleman right here. As you guys know, I interview lots and lots of people see the things that I do. So this right here, you see this? This is Mr. John Kavanagh. This is Mr. John Kavanagh of District 23 in the lovely, lovely city of Scottsdale, Arizona. You guys see what it looks like? That's what he looks like. His name's John Kavanagh. There's his name right there. I'd like to know where John Kavanagh's schedule is. I'd like to walk up to him with a camera and have a conversation with him. I'm a nonviolent person. I'm a member of the press. I just like to ask him some questions. I in no way, shape, or form would make a video saying I'd like to talk to John Kavanagh and then do something stupid and get thrown in a dungeon. So I'm just saying this openly, so if any member of the government sees this, I'd like to just have a conversation with him on camera. I'd just like to have a conversation with him. Obviously, I'm trying to change the world. X Factor's in the room, everybody. T-Roy, good to see everybody. Where's everybody at? Let me say hello to everybody real quick. How's everybody doing? Good to see you guys. Listen, I'm crowdsourcing this because thousands of people will see this. And so I want to know John Kavanagh's schedule so that I can walk up to him when he's between schedules and say, excuse me, Mr. Kavanagh, why did you write Bill 2319? Why would you want to hide transparency from the people of America? Why would you not want people to record the police, Mr. Kavanagh? I'd just like to know those answers. Why do you think it's appropriate to protect the feelings of police instead of protecting the civil liberties of Americans? Mr. Kavanagh, I'd like to have that conversation with you, sir. With all due respect, human being to human being I'm talking about, because I have more respect for your skin than you do mine, right? Because what can happen to me, you don't want anybody to be able to see, but see, yeah, I want people to be able to see what happens to other people's skin, unlike you, Mr. Kavanagh. So we would need to know his schedule. What's his schedule? He's a member of the Senate. He's a member of the Arizona Senate. I went to the school to try to find him. I couldn't find him at the school. I got an email from the director, Mr. Owens, and Mr. Owens said, if you'd like to speak to Mr. Kavanagh, I highly recommend you send him an email. He sent me his email address. So let's have a talk then. So And this is the reason why we have to stop guys like this in their tracks. How come we have to stop guys like this immediately in their tracks? Why do I need to hunt him down and get him on camera? I need to get him on camera explaining himself why he wrote a bill that we can't record police at the proper distance to make sure they're not violating constitutional rights. Why did he write that bill? We should be able to ask him that, because too many public officials are in the dark and nobody knows who's doing the dirty work behind the curtain. Because see, if you knew what they were doing behind the curtain before they did it, then we could go after the people who wrote those kinds of garbage bills that are working for the police state, prison state, industrial prison complex. I guarantee you, and I don't know the answer, I bet Civic Corps gives him money. I'll bet he's funded by the for-profit prison industry. Can anybody tell me if he's funded by the for-profit prison industry or not? His name is John Kavanagh. That's his name. John Kavanagh. He's in District 23 in Scottsdale, Arizona. I wonder if he's funded by Civic Corps. Do you think he could be funded by Civic Corps? I'll bet he could be funded by Civic Corps. Okay. So now, if you had known, let me ask you guys a question. If you had known in 2001 that the case of Atwater versus City of Lago Vista, that this case would completely and fundamentally strip you of all of your civil liberties, that it would say that you can be arrested for any violation of the law, any infraction of the law in 2001, in the case of Atwater versus City of Lago Vista, they wrote the legislation that said you can, if a cop witnesses you break the law in any way, shape, or form, you can be arrested by the cop, and that is not a violation of your Fourth Amendment right. Any infraction of the law. It's written that you can go to jail for any infraction of the law in the 2001 case of Atwater versus City of Lago Vista. How many people knew that? Did you think that the next day we wouldn't have protested in the streets if we knew that? And so you say, wait a minute, it's not a violation of your Fourth Amendment right? That's what he said. That's the actual holding that is written by the Supreme Court, by Supreme Court Justice David Souter, who's a liberal, 5-4 decision, Atwater versus City of Lago Vista. And they say that any infraction of the law is not a violation of your Fourth Amendment. Okay, well, what's your Fourth Amendment? The Fourth Amendment is the right of the people to be secure in their persons. You mean, so if any violation of the law, spitting on the sidewalk, littering, peeing in a corner when you're drunk after you leave a club, if you turn too wide in your car, it's a traffic violation, but a violation is in fact an infraction of the law at some level. So that means you don't have a right to be secure in your person. It is not a violation of your Fourth Amendment right. And it's not unreasonable to arrest you if an infraction of the law has happened. And so if we had known that in 2001, then we all would have been up in arms. In 1989, if everybody had known that Graham versus Connor would create the use of force continuum, would create the use of force rules, if we all knew that in 89, this case right here is going to determine how much violence can be used against you by police officers at any time, night or day, then you would have been up in arms the next day. The next day, we would have protested in the streets if they said use of force will be up to the reasonable officer on the scene. So the amount of force that the cop can use on you in any scenario is up to him. He can determine how much force to use on you. Use of force will be determined by the reasonable officer on the scene. If you had known that in 1989, you would freak out. You would go crazy. If you had known in 1980 that Australia Johnson would be thrown down the stairs in 1973 and in 1980 in Johnson versus Glick, the Supreme Court would make it so that you couldn't file a civil rights violation very easily if the guards in jail beat you up or hurt you or killed you. That's why I always tell people, if you're taken to the dungeon, remember, the 1980 holding of Johnson versus Glick makes it almost impossible for you to get any justice against the guards unless you have other witnesses and you have videotape. Be very careful what you do when you go to jail. Be very careful. If we had known in 1990, actually, you know what? We did know. And people still were okay with the DUI checkpoints in 1990 from Sitz versus Michigan State Police. If you didn't know, you should research this case. It's on OYA's. You should listen to it and you should research it. Sitz versus Michigan State Police is the reason why they can have DUI checkpoints in America. If you had known that this case would set up driver's license checkpoints, border checkpoints, If you had known what this would lead to later, you would have protested the next day. But no one ever told you. You are just learning possibly that SITS versus Michigan State Police is what allows police to set up DUI checkpoints. And of course, SITS versus Michigan State Police is an extension of Terry versus Ohio. It's just the way it is. If you had known in 1996 in Wren versus the United States that it would make it so that police could just pretextually stop your car, just make you pull over because they looked at your car and said, I'm suspicious of your car. I'm suspicious that you're driving in this particular part of town at this hour. I'm going to pretextually stop you. If you had known in 1996 that a pretextual stop means that the cops can stop you for no reason at all, they can just decide that they're suspicious of you and your car for any reason, just pull you over, you would have protested the next day, but no one ever told you about Wren versus United States. They told you a guy who was smoking crack on the side of the road tried to speed away from police and they got him. That's all you heard. Michael Wren is, of course, a black man. I hate to tell you that, but that's just the truth. If you had known in 2013 in Florida versus Harris that drug dogs can smell your car, and drug dogs now, you know what the exact holding of Florida versus Harris is? Empirical evidence has shown us that dogs have proven effective in finding narcotics. Therefore, we're going to allow that if a dog smells your car and barks, that is probable cause. Newsflash, probable cause right here. A warrant can be issued. A warrant can be issued when there's probable cause, because no warrant will issue without probable cause. Florida versus Harris makes it so that a warrant can be issued, and that's probable cause. That's the holding of Florida versus Harris. Read why a warrant can be issued. A warrant can be issued because of probable cause, meaning that Florida versus Harris, this right here, when the Supreme Court held that because dogs have been proven effective, therefore a dog barking is probable cause, means you can be arrested right then and there. If a dog barks at your car, just understand this. If you get pulled over and they say, hey, I'm just going to run the dog around your car real fast. If the dog barks at your car, you can go to jail right then, right there, immediately. The dog barking is probable cause. You understand that? So when that dog barks, if they search your car and the guy looks at you, he's like, you know what? I'm pretty sure you swallowed those drugs. I'm going to take you down and I'm going to get a warrant to do a cavity search. The dog barked. Remember why a warrant can be issued. A warrant for a cavity search is the same as a warrant for your car, is the same as a warrant for your house. A warrant can be issued because the dog barked. The Supreme Court said that a dog barking is probable cause, meaning that the dog can get your car impounded if the dog barked. That's all that has to happen. And by the way, once your car is impounded because the dog barked, you have to pay to get your car out. They're not going to let your car go. S-car go, S-car go. If you had known in 1977 that Pennsylvania versus Mims was going to make it so that when the cops pulled you over, they could order you out of the car and then Terry detain you, which means bend you over, put their fingers in your crevices, put handcuffs on you. If you had known in 1977 that Pennsylvania versus Mims actually means you have to get out of the car and then you can face detainment, there would have been protests in the streets the next day. But you didn't know that. Nobody told you. Nobody let you know. Nobody said, did you know that because of a Supreme Court ruling yesterday, that when the cops pull you over, they can now order you out of the car to Terry detain you, meaning handcuffs on your belly, on your knees, in the back of the car. But nobody told you. You didn't get to know. There was no notification. Nobody let you know that Pennsylvania versus Mims would mean you were going to be subjected to torture. And take it even a step further. In 2009 in Arizona versus Johnson, nobody called you the next day and said, hey, did you know that the Supreme Court made a holding last night that said that if you're the passenger in a car, the cop can order you out of the car. And once you get out of the car, he can Terry detain you. He can Terry detain you just because he told you to get out of the car. The Supreme Court did that. And while the media was busy celebrating this person right here, Ruth Bader Ginsburg, She's the one who wrote the rules. She wrote Arizona versus Johnson. She wrote that since Terry v. Ohio says the driver's detained, well, then everybody's detained. She's never faced a Terry detention. She's never been put in handcuffs. She's never been tortured. She's never been put in slave cuffs for 10 minutes. And the 10-minute handcuff challenge, more like an hour or 2 hours when you're put into detention in Arizona versus Johnson. And then once they put you in handcuffs in Arizona versus Johnson, they order you to get out of the car. And then you know what happens? They make you sit on the curb. And then cars drive by you and look at you and you're in handcuffs on the side of the street. You think she ever faced being in handcuffs on the side of the street in her little town? As you have to sit there in handcuffs because you're the passenger in a car and I didn't use my blinker? You think she ever had to deal with that? You think she ever had to face that? No, she did not. She did not. She also was the swing vote 5-4 in Mont versus United States that made it so that if you get out of prison early and you get rearrested, you then have to tack on your probation time, meaning she expanded the police state, prison state for another 2 to 5 years after you get out of prison. Because once you get out of prison, they have to let you know that you are their little weenie boy and you will be until you're dead. But nobody told you about Mont versus United States. You never even heard of it. It's not your fault. You're not a bad person. You're living your life. Nobody ever told you that 7 million people would go to a dungeon based on a 2005 case of Gonzalez versus Reich. No one ever told you that this case would mean that millions of people, and the number one reason why anybody will be arrested in your town today is because of the 2005 holding of Gonzalez versus Reich. No one ever told you. No one said to you, you know what this does? This makes it so marijuana stays on the criminalization list. That's what this does. Gonzalez versus Reich. Nobody told you that. You just heard there was a ruling against homegrown marijuana. What they didn't tell you is the number one arrest in your town is for marijuana. The number one reason why your jails are full is because of marijuana. And what this does, from 2005 to 2022 right now, 17 years, I'm going to guesstimate here. I'm going to say 3.5 million people have been to the dungeon because of a 2005 holding Gonzalez versus Reich. But no one told you that. How many people are for the war on drugs? How many people want that? Go ahead, raise your hand. Put the number 1. Hit the number 1. If you're for the war on drugs, let me put it like this. If you're against the war on drugs, hit the number 1. Hit the number 1 button. Push the number 1 button. Hit number 1. Let me see. Who's against the war on drugs? Who's against it? Who thinks we shouldn't have a war on drugs? Hit the number 1 button on your screen, please. Everybody hit the like button. Everybody hit the like button. Everybody hit the like button. Everybody reach down, hit the like button. Hit the number 1 if you're against the war on drugs. But see, nobody ever told you this. Nobody ever told you about the 2020 case of House versus Hodis. Anybody ever tell you about this case? Okay, so Mr. House is going up onto his porch. He's 19 years old, 18 years old. He lives in Detroit. I believe he's in Detroit. I'm pretty sure. He's going up on his porch. Hodis is on one of those routines. You know what he's doing? He's looking for somebody to do a pretextual stop. Wren versus United States. That's what he's doing. He's on a patrol randomly surveying neighborhoods for criminality. That's what Hodis is doing. He sees House. House has dreadlocks. He walks up onto his porch. House says, hey, give me your ID. What is Hodis doing? He's doing a Terry stop. He's doing a Terry stop on Mr. House. That's what he's doing. He's doing a Terry stop. That's what he's doing. So Hodis goes to Terry stop House, and House says, nah, dog, I'm not giving you my ID. I'm at home. And Hodis says, no, Mr. House, give me your ID. He says, listen, this is my mama's house. I'm home. Leave me alone. And Hodis says, no, you got to give me your ID. I'm suspicious of you. I'm suspicious of you. This is a Terry stop. I'm suspicious. And you know what Mr. House says? Mr. House says, I don't care if you're suspicious. I'm at my mama's house. I'm home. Leave me alone. Well, Mr. Hodis decides to beat the shit out of Mr. House, and he does. He beats him up. Him and 2 other cops, they beat up House real good, and they take him to the dungeon. Unlawfully, he was at his house. They attacked him on his own porch. Well, Mr. House sues. It goes all the way up to district court, to right before the Supreme Court. He requests certiorari to go to the Supreme Court where they hear your case. They denied it because this case right here takes on what? Qualified immunity. No one told you. No one informed you. No one educated you. Nobody has told you this. Nobody has told you about House versus Hodis. Nobody has said a word to you about House versus Hodis. You're just hearing about it. God bless you. That's why I made this poster, so you can read every case on here. Go onto the YouTube and look it up. Go onto Google, look it up. So now I'm showing you some serious stuff here, right? Now I'm showing you guys, this is John Kavanagh. This man right here, if he gets any further in power, he will continue to try to write bills that hide transparency so that we can't see what police are doing. This man is a cancer to our society. He's a cancer to being elected official. We have to get this man out of office. We have to run him out of office. He is not a good politician. He does not belong in office. We need to get him voted out of office. That is John Kavanagh, who wrote Bill 2319. So now let me lower down a little bit. Now that I gave you guys a lesson. So what happened? Let me just finish this real quick. So what happened? So let's just take a look real quick. Let me just show you guys one thing. Where's 2005? Let's take a look at 2005. You guys remember what I told you, right? Remember what I told you. Gonzalez versus Reich, what this did is this made it so that you would still be arrested for marijuana, because if homegrown marijuana is made legal, then it's normal that everybody's going to have marijuana. You would no longer be able to take people to a dungeon for having marijuana because it would no longer be illegal. But Ruth Bader Ginsburg and Scalia voted together to make sure that Gonzalez versus Reich would keep marijuana illegal. They were just to be so celebrated because no one knows anything about them. How loving was he in Graham versus Connor? Did you read what he said? Did you hear what he said in Graham versus Connor? Horrifically bad. Horrifically bad person. Horrifically bad. Okay? So now let's go here. There's the dungeon. Here's the dungeon system going to 2021. Okay, now let's take a look. So right about here is 2005, right about here. So you're talking about, you know what I'm saying? 750,000 million people maybe. Each year exponentially you get to double that number. How's that? Isn't that just amazing? Isn't that just amazing? So now let's drop down here and let's really get into some John Kavanagh. So let's find out. Here's what I want to know. Here's the reason why I came on the live. And now that we got a few people in the room, this is the reason why I'm here right now. I have something I have to work on tonight, so I got to get off here soon. But what I want to talk about now is, what's John Kavanagh's schedule? What's his schedule? What is John Kavanagh doing? He's an Arizona state senator. And so they have a schedule. I went to the school to go talk to him. He has a responsibility to face the press and the constituents. So then I go John Kavanagh 23, and then I go schedule. Does anybody know this guy's schedule? I want to talk to him on camera. I want to walk up to him on camera, and I want to say, hey, Mr. Kavanagh, why are you writing bills that make it so that we can't have transparency? Is that better? That's better. Okay. So there's John Kavanagh, Senate member. He's a Senate member. So what's his schedule? Because we want to walk up to him in public and ask him, why are you writing bills that oversee most of Scottsdale? Anybody from Scottsdale? Committee appointments, President Pro Tem. He retired from as being a cop. We know that. So what's his schedule? Does anybody know his schedule? I'm trying to find his schedule because I want to ask him on camera why. What is this? No, these are sponsored bills. Oh, you guys want to see 2319? Let's look at that one. So here's the bill. Let's just go like this. Bill 2319. Okay, so there's Kavanagh Bill 2319. I want to see the actual bill. I want the actual bill. I want to see the actual bill. I don't want to just see anything. I want to see, there it is, 2319. So let's take a look. There it is. Let's take a look. Wow, look at all these green check marks here. Are all these people voting for 2319? License denial, prior legislation, votes, summary, tracking information. We'll just get a paraphrase to us so you guys can understand. So what this says, former cop turned Arizona senator wants, of course they give me the ad right away. Former cop, Arizona senator wants to get permission before filming police. So that means you have to ask for your rights. You have to ask the government if it's okay if you write. 2319 would make it illegal for individuals to record police officers without their permission. The cops got to give you permission to film him. Oh my God. Oh my God. Would make it illegal for citizens to video record police within 15 feet. So wasn't George Floyd killed within like 3 feet, 4 feet? Like if you're 15 feet away, they could have taped that off. We don't want that. I mean, what I'd like is the actual legislation. Taking photographs, video, and audio in public spaces is a constitutional right that includes law enforcement officials carrying out their duties. And this is the ACLU of Arizona. So what is his schedule, though? That's what I want to know. That's what I want to know. Can anybody tell me his schedule? That's why I came on here, because I'm only one guy. I'm only one human being. And I want to know what John Kavanagh's schedule is so that I can ask him why he's writing bills to benefit cops. And I think that we need to present this to the constituents of Scottsdale in District 23. Why is an ex-cop writing the bill? How come that is? Why is that? I mean, why is that? Why is he writing the bills? I can't even get my head wrapped around it. I can't even get my head wrapped around it. It just pisses me off so much. And now we're gonna go, I think it's OEA's McNutt versus Oregon. I'm just gonna show you guys a couple things here. Not United States versus Oregon. Show you guys something else. Sorry about that. I want to show you guys something that you're going to get I think I was listening to this yesterday. Yeah. So this is, it's pretty tough. It's pretty tough to listen to, just so you know. Tennessee versus Garner is really, really hard to listen to, because it's you know, it's just difficult.
We'll hear arguments first this morning in Tennessee against Garner and the consolidated case. Mr. Klein, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court, there are two issues in this case. The first deals with the constitutionality of a state statute with regard to the use by a police officer of all necessary means to effect an arrest. The second is whether the municipality's use of deadly force to apprehend a fleeing burglary suspect after exhausting all other reasonable means is constitutionally permissible. The reason the city asked for certiorari in this case is that it has substantial public interest in being able to apprehend persons fleeing from serious crimes such as burglary in the first degree.
Okay, what they're talking about is being able to shoot people as they run away. That's the common law statute that the fleeing felon. If you can shoot the fleeing felon if they're running away, and that's what this case is about. Can you shoot a fleeing felon for running away?
The facts in this case are such that they lend themselves to show that the officer involved had probable cause to believe that a felony had been committed. On the evening of October 3rd, 1974, the police received a call to come to the scene of what was an apparent breaking and entering. The police arrived on the scene. They were advised by the next door neighbor that, quote, they are breaking in next door. The officer then proceeds to survey the situation and then to move into the area where the reported burglary was taking place. The officer goes down the side of the house and, is doing so, notices as he comes to the rear of the house that there was a window that had been broken and a garbage can beneath the window, which appeared to him that someone had used the garbage can to get up to the window, had broken the window, and then had gained admittance to the home. This all took place at approximately 11 o'clock in the evening. The officer then, as he reaches the back of the house, sees an individual exiting from the house and running toward the back of the yard. There was a lot of clutter in the yard at the time. There was a small mesh fence that was an obstacle to the police officer, which as he started to move into the backyard. There was a chain link fence in the back of the yard, which was approximately 6 feet tall. The suspect, after exiting the back door, immediately proceeds to the fence and then pauses at the fence in a stooped position. The officer gives the command to halt, police. At this point, the individual turns and looks in the direction of the police officer and does remain in this stooped position momentarily. And then as the officer is about to make his advance forward to attempt to apprehend the individual, he then begins to jump and vault over the fence, at which time the officer fires, and unfortunately it results in the death of the suspect.
It might be unfortunate if the cop wasn't carrying hollow tip bullets in his gun. He loaded his gun with hollow tips that spread apart inside of the human body.
Now, these basically are the facts that are involved. As I pointed out earlier, there can be little, if any, question that at the time the officer arrived on the scene, there was probable cause, if not more, to believe that a burglary in the first degree had been committed. Burglary in the first degree under Tennessee law is the breaking and entering in a dwelling place in the nighttime with intent to commit a felony. And the Tennessee legislature has determined that burglary is a serious crime, which, if nothing more, is evidenced by the fact that it carries a penalty of not less than 5, no more than 15 years. The officer also made the judgment or determination, as he so testified, that he could not apprehend this individual by any other means. Now, under Tennessee law, it's clear that an officer must use all means available to apprehend a fleeing felon, and he is only justified in using deadly force as a last resort. And this officer testified that because of the conditions out at the place, the fact that it was dark, he was unfamiliar with the neighborhood, and that beyond the fence there was growth, as I think he described it, Johnson grass, which was rather tall, that he knew that once the individual got beyond the fence, there was no chance for him to apprehend. And that's the reason that he used the deadly force to attempt to apprehend.
So they have to get you. You have to be gotten. You cannot get away. This is from the 1962 Model Penal Code. Started in 1952, peer-reviewed in 1959, published in 1962. This comes directly from the Model Penal Code that if a felon is fleeing, you can kill him. He's the one that wrote it.
Now, the court proceedings below,
he wrote it, the Model Penal Code.
The district court found
that man
in favor of all defendants. Named in the original action was the city of Memphis, the individual officer who was on the scene, and 2 supervisory personnel. The case was appealed to the Sixth Circuit Court of Appeals and was sent back because in the meantime, this court had decided the Monell case, and that the Court of Appeals decided that the case should be remanded in light of Monell to further consider whether there was any liability on the part of the city. The judgment as to the individual defendants was affirmed by the Court of Appeals. The case was reconsidered by the district judge, and again the district judge found that the city was not liable, found in favor of the city, and the case went up again. The second time, the court declared that the Tennessee statute allowing the use of deadly force was unconstitutional. The reasons given were that it did not put sufficient limits on the use of deadly force, it was too disproportionate, and it did not make distinctions on the magnitude of the offenses.
Mr. Klein?
Yes, sir.
Did the Court of Appeals say that the statute was unconstitutional across the board or on its face, or did it just say it couldn't constitute a defense in this action?
It said it's unconstitutional across the board.
Did it intimate that there was some First Amendment problem involved here?
No, sir. There was no indication. It was Fourth and 14th Amendment were the two bases that the court used for declaring it unconstitutional. The court said that the use of deadly force could only be implemented if a suspect had committed a violent crime, there was probable cause to believe that the suspect was armed, or that he would endanger the physical safety of others if not captured. Now, the standard which the Court of Appeals used was based upon the Model Penal Code.
Okay, this is Frankfurt. He wrote it. This man right here. He wrote the Model Penal Code with a guy named Henry Waxler.
And it's the city's position that the Model Penal Code was implemented was to be used as a guide for legislatures, and that really the purpose of the Model Penal Code should be as a guide for legislatures in the event they see fit to enact legislation to cover situations such as this. The reasons the city disagreed with the Sixth Circuit opinion are, first, the city feels strongly that the court erred in concluding that this was not a serious crime. Again, I emphasize and reiterate, the crime involved was burglary in the first degree. And the court doesn't really deal with why it considered the crime to be nonviolent. They did label it as a so-called property crime. Also, the city feels that the standard which was imposed, is based upon the Model Penal Code, is an impediment to apprehension. Because of the standards placed under the Model Penal Code, it puts an undue burden on law enforcement in situations such as this in attempting to apprehend fleeing felons. Because of the standards set out in the Model Penal Code, it requires a police officer to make an on-the-spot constitutional analysis and still react to the exigencies of an emergency situation. Because of these standards set out by the Sixth Circuit, it's difficult to determine how an officer will ever know, reasonably or otherwise, if the felon is allowed to escape, whether he will ever again be free to commit another crime if not apprehended.
Okay, so the Model Penal Code, written by this guy, says that if a guy is fleeing, a fleeing felon, that the cop can shoot him in the back. That's what the Model Penal Code says. That's why it's a constitutional court right now. They're going to decide whether or not the Model Penal Code is a constitutional standard to shoot you when you're fleeing, when someone's running away. That's what this whole court case is about. And he wrote it. He wrote the Model Penal Code.
Mr. Klein, may I ask you a question?
Yes, sir.
Supposing there had been another officer on the other side of the fence, unbeknownst to the man who felt it necessary to shoot the fleeing felon, and he had later been, say he'd missed and he'd actually been apprehended, what penalty could the state have imposed on him under your code for the crime of not submitting to the officer's command?
Not submitting to the arrest?
Just for fleeing. And
Yes.
what sort of crime is it?
Your Honor, I might add, factually, there was another officer on the scene.
Well, but you understand my hypothetical.
Right, sir.
Just say instead of shooting him, they've been able to catch him. He's committed a crime surely by escaping in defiance of the officer's command to halt. Right. I'm just wondering, what is the penalty under Tennessee law for that crime?
Well, of course, he's still in process of perpetrating burglary in the first degree.
I understand he's subject to penalty for that, but I assume he's committed a separate offense when he flees.
In refusing to obey the officer's
Correct.
command to halt.
Yeah.
Your Honor, please, there is a city ordinance which covers that, but it's a very minor offense, and it really would be a city violation. It's not a state violation.
It's not a state violation.
No, sir, it is not a state violation. Of course,
So the only deterrent that the state imposes for that offense really is to shoot the man at the time.
well, if they cannot apprehend him by
Right.
any other means.
Shoot him.
That's right.
And it's
But if they can apprehend him, they're basically, you're telling me there really is no legislative deterrent other than the threat that if you don't get away, you might get shot.
that's correct.
That's it. You get to shoot him. That's it.
What is the penalty for first-degree burglary in Tennessee?
That's Lewis
Not
F.
less
Powell.
than 5 nor more than 15 years.
Sorry, guys. That's Lewis F. Powell. So you guys should start to
What is the
learn who
penalty
they are.
for first-degree burglary in Tennessee?
Not less than 5 nor more than 15 years. And if a weapon is involved, then it becomes not less than 10 nor more than 15 years.
No more than 40,
15, sir.
where a weapon is involved.
Where a weapon is involved, not less than 10 nor more than 15 years if a weapon is involved. So the Tennessee statute makes it even more serious crime if a weapon is involved. The city further contends that that what the Sixth Circuit has done is imposed a standard which should be left to the legislature. It's a standard of morals, a standard of public policy. And it's the position of the city that this is something that should be left to the legislatures. What the court did was, under the of constitutional law, is imposing upon the various states which will be involved its own standards. Furthermore, the level of a crime which would justify use of force should also be left to the legislature. Tennessee is determined that burglary is a serious crime, and therefore it makes it all the more important that in the situation such as this, that the right to apprehend is compelling, and is certainly a compelling state interest. The legislature has an interest in protecting its citizens against burglars. And of course, we confine ourselves to the facts of this particular case. And when we talk in terms of compelling state interests as opposed to the rights of the individual, the city takes the position that the individual burglar has no constitutional right to commit burglary.
Listen.
And escape the consequences. And he has no constitutional right to flee from burglary when told
to stop. The burglar has no constitutional rights because he's a burglar. He should be killed.
Now, in this particular situation, when the police officer arrived on the scene, all the individual had to do when confronted by the officer and told to stop was to do so. And that would have been an end to the situation.
Do as you're told.
So really, there are two things that are involved from the standpoint of the individual. He has put himself in the position by committing the burglary, which he takes to do himself, and certainly assumes a certain risk of what might happen when he does put himself in that position.
Unless he's a 14-year-old kid who's mentally slow, which was who Edward Eugene Garner was.
And then secondly, when told to stop, all he has to do is stop.
Unless you're 14.
And the matter is at an end. And then all the constitutional rights that he contends that were deprived of him come into play. He gets a fair trial. He gets an opportunity to be heard. But in this particular case, the individual chose to perpetrate the crime and chose to continue after being told to stop.
Mr. Klein, may I ask you a question? In your reply brief, you emphasize Memphis policy, and you say that it's limited to situations where there are violent crimes, and you list the types of violent crimes.
Yes, Your Honor.
Does the Memphis, you call it a policy, is it a state ordinance, a city ordinance?
Your Honor, what has happened is the city has implemented what's known as a general order.
A general order by the city council?
No, sir, it's by the city police department.
Police department?
Yes, sir.
Does the police department have authority to limit the full scope of state law?
No, it does not.
Do you consider do you consider this ordinance consistent with state law?
It is under, yes, sir.
Is state law limited only to serious violent crimes?
Well,
it doesn't say so, does it?
It doesn't say so, but I might add the courts in interpreting the state law, and again, the state law is really the common law. And the courts in interpreting the state law have said, even as far back as 1879 in the case of Renault versus State, that the statute only intended that the use of deadly force be against what I categorize as serious crimes. And that even said...
Serious or violent?
Well, serious. They didn't use the word serious.
Okay, and the policy of the police is what a serious crime is. The police made the policy.
What they said in Renault versus State is that if there were certain crimes of lesser degree, felonies of lesser degree. They talk in terms of felonies. But if there were certain felonies of lesser degree, then there may be some question. But I want to emphasize that the state courts have always interpreted this statute to apply to what I would classify as the more serious category.
Do you draw a distinction between serious and violent?
Well, my distinction of serious is that it's serious, as I indicated, because the legislature said it's serious. Violent crimes are those such as burglary in the first degree, which have a great potentiality for violence.
If there's a potential for violence, it's the same as violence. A 14-year-old kid going through his neighbor's window to get $10 off of the coffee table is a serious crime. The police have created a policy that you can shoot for serious crimes.
You may have a burglary, not in fact involve violence. It may, on the other hand, may involve violence. For example, in the case here, the officer, when he arrived on the scene, didn't know what was going on inside. There may have been some victims laying on the floor.
Oh, of course.
Suppose this house or building, instead of being a private residence, had been a deserted building in a field somewhere. Would the officer still have had the right under Tennessee law to shoot a person fleeing from the scene who apparently had broken into it?
Well, I can't say that a dwelling in a deserted field would be burglary under the Tennessee statute. At best, it would be burglary in the third degree, which carries a lesser penalty.
But your Memphis policy would cover burglary in the
third
degree.
Memphis policy would cover burglary in the third degree. But again, the point of this is that burglary in and of itself, and again, that's what we have in this case that's before us today. Burglary is a serious offense with a great potentiality for violence.
So remember, you guys have to, when they say this, don't forget what they're saying here. The Memphis police policy, they're skipping the word police here. The Memphis police policy is that burglary is a serious crime and that the model penal code is to be enacted to shoot a fleeing felon.
There may not have been a violent act that was committed in the example that Your Honor gave with regard to a dwelling house in a deserted field. The idea that an individual who will break and enter is the type of individual that has a great propensity or likelihood for violence.
No.
Whether it be, it may not be at that time, but it may be in the apprehension of that individual.
No. The person who breaks in the darkness is a coward. The person who attacks you physically is a violent offender. The person who breaks in when no one is looking is afraid of everybody. This is the opposite. The lawyer's just making things up.
And it's by the nature of the crime, the nature of the person that will perpetrate such a crime, that it's our position that therein lies the great potentiality for violence.
Mr. Klein, may I ask you a question about what we mean by the term deadly
Judge
force?
Paul Stevens?
Do we mean that the officer can deliberately shoot to kill the individual?
Yes.
Well, deadly force means using that force, whether it be
yes.
Usually in the context we think of it, it would be a pistol.
Yes.
But and it also means, I take it, that he may deliberately shoot to kill.
Well, when you say deliberately, Your Honor,
Or
yes,
doesn't it mean that? I'm just trying to understand.
Right. Yes, when he pulls his weapon, that's what he's intending to do.
So it's really more than apprehending him then.
No, it is apprehending, and that's the purpose of it.
Well,
it's the attempt to apprehend, and that's the last resort. That's the last thing he can do. If it's not that,
you could let him go.
The perpetrator's gone and free to commit a felony another day or down the road.
Let him go.
John, please, I would like to reserve what time I will have left.
Mr. Klein, let me ask you one question, if I may. In your introduction to your argument in your brief, you say that the Tennessee courts have interpreted the statute to allow the use of force that may result in death. If the officer reasonably believes that the person has committed a felony, he notifies the person that he intends to arrest him, and he reasonably believes that no means less than such force will permit the escape. Now, I would read that as indicating that if the officer thinks that by shooting to wound the person and he can prevent the escape, that he is obligated to do that.
Well, that's true, but to be candid with Your Honor, the police policy has been to shoot for the mass. The reason
Shoot for the what?
For the mass, which is
The chest.
and the reason for that is that it's obvious that one who uses a pistol cannot be as accurate as, say, a marksman with a rifle because of the circumstances, the fact that he may be running or he stops, and the fact that a pistol is just not an accurate weapon.
What you're talking about really is a shot that has a potential for killing. Is it not a shot intended to kill?
That's correct, sir. No one can argue that once you use a firearm, there's always the potential for killing. And it's not that the officer is intending to kill. He's intending to apprehend or attempting to apprehend.
Oh my God.
And that's the only means he has left to do it.
Oh my God. Okay, let's take a break here real quick. Okay. So let me help you guys out. I'm for rule of law. I'm for law and order. In today's world, with the Ring camera and your cell phone and cameras everywhere, you no longer have to get that guy right this second. You're going to get him if you really want to get him. You can't run down the road in America anymore. You can't speed off in your car and get away. So now, if we're going to go by that ridiculous logic right there, that's not the only chance to get him anymore. Not anymore. Now we have facial recognition. There's all kinds of ways to get him now. I'm not for people robbing your house and getting away. I am for people not being shot down dead in the street because they've resulted to breaking into your house in the darkness. Eugene Garner was a 14-year-old kid who saw a $10 bill on his neighbor's coffee table and decided to sneak into their house and grab that $10 bill. Someone just gave me $5. Thank you. Someone just gave me $5. And Eugene, and by the way, now listen to Rehnquist. Rehnquist is a total cop-sucking authoritarian throughout all of his cases. Rehnquist is a cop-sucking authoritarian. Listen to Rehnquist do what Warren did, Earl Warren, where he says, well, if the cop's going to shoot him, he's not trying to shoot him to kill him. He's trying to shoot him to apprehend him. If you shoot, by the way, and just so you guys know, a little caveat for you, I've really researched this case down to the bone. The cop who shot him his gun was full of hollow tip bullets. If you haven't been in the military or you're not from the rural America, hollow tip bullets are a very specific type of bullet. I think they're illegal in California now. And when a hollow tip bullet goes into your body, the cut of it goes 4 different ways. So the bullet enters your body and then it fractures into a bunch of different areas. So if you get hit right here, the bullet fractures and goes through your chest. That's the kind of bullets that the cop was carrying. Eugene Garner was shot dead in the back of the head, right square. The cop hit him right dead in the back of the head. The hollow tip bullet went into his head, expanded in a bunch of directions. Eugene Garner was dead before his body hit the ground.
Mr. Attorney General.
Mr. Chief Justice, and may it please the court, in considering the Constitution.
Last thing, I double dog anybody to just look up a Warren Burger of the Warren Court. He was the Chief Justice, probably right down in the bottom 3 or 4 justices of all time. He was a total, complete piece of garbage. Just look up Burger, even Wikipedia. He's so bad that even people know on Wikipedia how bad Burger was. Reading his decisions, I had to literally vomit a couple times, just lean on, because he's just such a fraud, piece of trash. I hope you burn in hell.
Of the statute here, I believe that there are 2 overriding questions for the court. First, was the Court of Appeals correct in rejecting the common law rule and establishing as a federal constitutional mandate that deadly force may only be used when the officer has probable cause to believe a violent, as distinguished from a nonviolent crime, has been committed? And secondly, is the federal court, under our system of federalism, the appropriate body to make this ethical and moral public policy decision, or is it more appropriately left to the state legislature as the elected representatives of the people. And we submit that the answers to these questions will turn on an understanding and a recognition of the state's substantial interest in being able to apprehend serious criminals and preserve the public safety. It's the position of the state that Section 40-7-108 of the Tennessee Code,
which allows you to kill people,
which is generally an embodiment of the common law rule, as it has been construed over the years by the Tennessee Supreme Court.
Common law means you can shoot a fleeing felon if they're running away. So he's just saying right here that the Tennessee statute, you can kill people when they run away. That's what we're saying here.
Is constitutional as applied to the facts of this case. And as I have indicated, I think there are serious considerations before the court.
No, Jeff.
The ethical and the moral judgments of public policy that a society must make are judgments we believe better made to the state, in the state legislature than in the federal court. And the ability of the state to effectively apprehend suspects that are fleeing from felony crimes reflects a substantial interest on the part of the state and does not amount, as has been suggested, to punishment of the suspect. And in balancing the interest in this case, we're talking about that substantial state interest in apprehending criminal suspects measured against the right of the criminal who can lawfully submit to arrest and possibly lose his liberty, because if he submits to arrest, he may, in all probability for a felony, go to jail, so he loses some of his liberty and freedom, or to disregard the lawful order of the police and risk the possible losing of his life if in the apprehension process the force that was used was deadly force. These questions, we believe, under the 14th Amendment, will allow this court to recognize that the felon should not have a right to unwarranted protection from apprehension, which would jeopardize the public security in not being able to bring a criminal to justice.
Okay, so remember the first lawyer? The first lawyer was on the side of Edward Eugene Garner. Do you understand that? You guys heard the first lawyer, right? That was Edward Eugene's Garner lawyer. And this is the lawyer against Edward Eugene Garner. Do you notice the difference? The other guy hammered Garner, and this guy's hammering Garner. There's no difference.
It is the apprehension process that is necessary before any of the other criminal justice procedures can come into play. And unless the state is able to recognize and to implement its substantial interest in arresting and apprehending felonies, then the state has lost forever its ability to do that. And the rule which would allow a fleeing felon to disregard the fact and to say that the police have no threat or no ability to use maximum force if necessary will encourage in property crimes or burglary crimes, as we have here, will encourage the criminal to run each time. If there is a person helping him who merely looks out for the police, all that has to be said is, here come the police, and they know that the police cannot use all necessary force to apprehend them, it becomes basically a foot race.
Are you guys listening to this? I mean, are you hearing what they're saying? If you're a burglar and you commit burglary, they should be able to shoot you. And you should know that before you commit burglary, you're going to get killed. You die. I mean, I'm not for burglary. I don't know if this is the best way in the digital era. Maybe back then this is a good thing to have, but we have cameras everywhere now. We don't need to kill people as they run away anymore. They're going to get caught on camera. It's 100% they're caught on camera.
The Court of Appeals drew the line in its setting up, we think, of a constitutional mandate based on the Model Penal Code rule, which is at variance with at least half of the state rules between violent and nonviolent felony.
Okay, we think a constitutional mandate based on the Model Penal Code rule, which says you can kill them when they run away, written by Frankfurt.
And we believe that there are other indicators of the state's substantial interest in apprehending criminals other than violence. And if the court will allow me, I would like to leave.
Mr. Cody, I guess some states have adopted a more restrictive provision than Tennessee has, and something more along the lines of the penal code, model penal code.
That is true.
Has that proved to be workable in those states, do you know?
I suspect that would depend upon that legislature's analysis of how it has worked. The point that we have tried to make in our brief is that if a police department or a city or a legislature makes a rule which is more restrictive, or like the Court of Appeals rule, then it is just that. It is a rule that the police department or the legislature, looking at the changing circumstances, may wish to change again. But if this court...
Well, I understand, but I thought you were arguing that any more restrictive standard would be unworkable, and so I was curious.
Well, I have no information, but I believe that it would be unworkable if the officer is put to the task of trying to make this probable cause analysis when he arrives at an arrest scene.
Well, certainly the fact that other states...
Well, before we go on, let me just show you real quick. You heard Sandra Day O'Connor just speaking. So they're going to make a nothing burger ruling. But here's what Sandra Day O'Connor says in the dissent, just so you know, that woman who was just speaking, that the majority went too far in invalidating long-standing common law and police practices contrary to the holding. Chief Warren Berger and Justice Rehnquist joined the dissent. So remember I said the Berger was a giant piece of garbage? Berger voted that you should be able to shoot people when you run away, as did Rehnquist, along with Sandra Day O'Connor. You see, these are the people. Let me just go by ideology here. So this is by ideology. The conservatives on this side, on this particular court, on the Berger court, just said that you should be able to shoot him. He's Chief Justice, and he'll be Chief Justice after him. So the Chief Justices back to back, William Berger, total piece of garbage, and then followed. Rehnquist is consistent. He's a consistent a-hole, but he's consistent in his holdings. I've read a bunch of his holdings. And Berger right here, total piece of fraudulent trash. But remember, the two most conservatives, he's Supreme Court Justice, and then he's going to be Supreme Court Justice. And Sandra Day O'Connor, the first woman on the Supreme Court, she's also a conservative. Well, she's a swing voter. She votes liberal too sometimes. But then she's going to say that you should be able, the majority. Now, what their holding is going to end up being is that you're not allowed to shoot people as they run away. It's against their constitutional rights. There's a caveat, though. Unless pose significant physical threat to officer safety or the community. This is Terry v. Ohio right here. That's Terry versus Ohio. You guys do me a favor. Everybody reach over and hit the like button. Everybody reach over and hit the like button. Just reach down here and hit the like button. Type the number 1 right in here for the chat. Everybody, if you're liking what you're seeing, just hit number 1. Just hit the number 1 button, or W for the win. W for the win. Type number 1. Hit the like button for me, please. Everybody hit that like button. Just take a second. Let's go right back to it. Just I want to let you know that she's asking these questions, but she thinks you should be able to shoot people in the back as they run away. That's just letting you know. He's going to ask questions, but he thinks you should shoot people in the back, and so does he. Okay? And then the rest of them say you can't shoot people in the back unless the cop's afraid for his safety.
Have a different rule would indicate that it works.
That it has worked for those states, or that they have chosen.
So this is, I'm sorry. I was calling him Frankfurter. I'm sorry. I was thinking of a different Supreme Court justice. This is Harry A. Blackman. Harry A. Blackman is the co-author of the Model Penal Code that invokes common law that you can shoot people when they run away. He's going to write it with a guy named Henry Wexler. Henry Wexler. These two guys so his work in the model penal code right now is in court before him right now. He's watching them discuss the model penal code that he wrote, that Harry Blackmun wrote with Henry Wexler. You understand? The constitutionality of, he's going to vote that the model penal code is now unconstitutional. He wrote the model penal code. He's going to vote in Tennessee versus Garner that the fleeing felon rule is no longer valid. You can't shoot people in the back unless it's in the name of officer safety. So they still created a caveat. He said, he wrote in the model penal code that you can shoot people in the back when they're running away. And then they invalidated it in Tennessee versus Garner unless it's for officer safety. So what changed? What changed? As you're running away, the cop says, I was afraid he was running toward a gun. He could still shoot you in the back. So what Harry Blackmun wrote in the model penal code is still law today, essentially.
Have a different rule would indicate that it works.
That it has worked for those states, or that they have chosen to let some fleeing felons escape rather than jeopardize their life. But we contend that that's a policy decision for the legislature to make.
Would you take the same position with respect to a fleeing felon whose felony is an antitrust violation?
The court, please, that makes a difficult question, but I think that I would have to answer that if there was a state antitrust statute that provided a sufficient enough penalty to indicate that the state's substantial interest felt that that was a serious crime, then they could authorize deadly force. The situation never arises because they can identify that person, and you don't ever get to the last resort.
Garbage.
May I ask one other question, please? You have a question?
Go ahead.
In measuring the state policy at stake, do you agree with Mr. Klein that there is no legislative determination of the appropriate punishment for fleeing in these circumstances?
I think that's correct.
General, I was going to ask you a question somewhat similar to Justice Blackmun's. The Court of Appeals stated that the question in this case was whether, under state law, a nonviolent fleeing felon, unarmed, could be shot by the police to prevent his escape. I'm interested in whether or not you think the Supreme Court of Tennessee would apply its statute to an unarmed, nonviolent, fleeing felon.
Listen to this.
If the court please, the Tennessee Supreme Court, in the only case that directly seemed to refer to this, had a property crime, the stealing of a small amount of merchandise. And the court in that case said that we would not extend the privilege to that case. It's difficult, however, to see whether it's because there were other means of apprehension or not. I think that the Tennessee Supreme Court would of necessity, based upon some reasonable interpretation, make the crime one that had enough seriousness to it to reflect a substantial state interest.
You do not draw the line with respect to violent and nonviolent crimes?
No, I do not. I think that's the error in the Court of Appeals.
No, I do not. Do you guys understand what was just said here? I know you guys are smart. I'm not trying to be. I just want you guys to see the words here. Look at the words. I won't go backwards, but the Tennessee court and the court, you don't get the privilege to shoot someone as they run away, the privilege to shoot. And then it says, do you think that it's based on violent? He says, do you draw the line with respect to the fleeing felon to the difference between a violent felon and a non-violent felon? And he says, no, I do not. I think the Court of Appeals made an error. If you run away from police, they should be able to shoot you.
I think that's the error in the Court of Appeals.
Winter?
Mr. Chief Justice, and may it please the court, I'd like to start by trying to address some of the questions. In answer to Justice Stevens' question, the maximum penalty for fleeing from an officer under the Memphis Code is $50 fine. And that's the citations for that in footnote 31 of our brief. in reference to the question about the workability of the standard adopted by the Court of Appeals, asked by Justices O'Connor and Blackmun and Justice Powell, we would point out that not only do the majority of the states apply a rule consonant with the rule adopted by the Court of Appeals, but the overwhelming majority of municipal police departments in this country, something at the rate of 75%, apply a rule similar to that adopted by the Court of Appeals. The experience under these statutes, under these municipal policies has been investigated. I would point the court to the amicus brief filed by the various police organizations and over 30 individual police departments in this country from common law and non-common law states alike in support of our position in this court. And they recount the studies that have been done in these jurisdictions. Arrest rates do not go down. Crime rates do not go up. The only thing that is affected by a more restrictive deadly force policy is the rate of officer safety, and the rate of officer safety improves under these more restrictive policies.
There it is, right there. The more you create policy for officer safety, the more we die, and the more safe they are, but the more we die.
After the event, it developed there were 2 dead bodies in the house. A third person who was seriously wounded alive, who later identified the fleeing felon as the person who had done the killing and the wounding.
Oh my God.
What would be your view?
Well, I think the Chief Justice's question points out one of the problems with my opponent's position, and that is...
I got to address it. Okay? If you're going to kill someone, look at his example. This is what Warren Burger, he's going to vote that you should be able to kill someone if they run away. What if the event developed where there were 2 dead bodies and a third one was seriously injured? You didn't stop anything by shooting the guy running away. The 2 dead bodies are still going to be there. The injured person is still going to be there. The difference between 1989 and today is the guy running away will never, ever get away. Not in the digital era. You cannot hide. You cannot get away anymore. That's why I will not break the law. You're not going to get away. So his ridiculous, authoritarian, murderous example is not only stupid, it's irresponsible as the Chief Justice of the United States of America. Burger, I hope that you are... Oh, I hate him. But I've read his cases, so there you go.
That is, oftentimes there are other means of apprehension short of killing the fleeing felon. Eyewitness identifications, evidence on the scene. In this particular case, the officer...
Before you get to the eyewitness, you have to apprehend the individual, don't you?
If the officer can, certainly.
Yeah. But if he isn't apprehended, the eyewitness isn't much help.
Well, if the eyewitness can identify him, then the witness is of a lot of assistance. In this particular case, the officer, when he ordered Garner to halt, and Garner did halt, the officer was able to see Garner. Now, it's possible that he would have been able to make an identification after the fact.
In today's world, we can always identify them because everybody's got a camera. There's a camera in the house. There's a camera on the cop. You don't got to shoot people anymore. We got them on camera.
Well, do you think the officer was able to know whether there were or were not some dead bodies in the house?
No, but the officer had no reason to believe that there were any dead bodies in the house. And I think that is a critical point because one of the major differences between our position and the position of the city and the state is that they would premise the right to kill of a police officer on what the officer does not know. But this court has held, and I'm thinking of Your Honor's opinion for the court in Brown versus Texas, that the Fourth Amendment requires police actions to be governed by what the officer does know. Specific objective facts indicating society's legitimate interests that require a seizure of a particular individual. The Fourth Amendment answers that question for us because it requires that specific objective knowledge on the part of the police officer before he acts. Now, Justice Powell asked about the nature of the crime and the punishment for first-degree burglary in Tennessee. We would point out that the court ought to be clear about the nature of the underlying crime in this case. First of all, if Garner had been guilty of first-degree burglary, the punishment would have been a maximum of 15 years. This first-degree burglary statute is the equivalent of the third-degree burglary statute in South Dakota that the court discussed in Solon versus Helm. It defines the exact same crime with the self-same punishment of 15 years. It is not a first-degree burglary statute like many other states, such as New York, that define first-degree burglary as a life-endangering burglary where the burglar may be armed or where harm results to a victim. So although it's first degree as a matter of Tennessee law, this is not the first degree crime defined by many of the states, and is equivalent to the third degree burglary that this court has already addressed in Solem. And I would point out that the court in Solem versus Helm recognized what is in fact the case, that this kind of third degree burglary is a nonviolent crime. It is a property crime. It's a property crime. It's listed under crimes against property in the Tennessee Code. Numerous state courts have observed what this court observed in Solem, that burglary is not a violent crime. I'm thinking of the Lewis case from Florida, cited in our brief, as well as the Brown case from Alaska, miscited in the city's reply brief. In Brown, the Alaska Supreme Court held that burglary was a serious crime against property, but not per se a violent crime.
Mr. Winter, how old was this victim?
The victim was 15 years old, Your Honor, and the district court found in two places, and referred to A10 in the appendix to the petition for certiorari, and at A5 footnote 3, that the officer reasonably believed that Garner was a juvenile. The officer misjudged by 2 years, but he thought that Garner was 17, possibly 18 years old. Under Tennessee law, he could not have been prosecuted for burglary. Either based on the actual facts that as 15 he absolutely could not have been prosecuted as a felon. He would only have been consigned to the juvenile court and perhaps a judge delinquent, which is an expressly non-criminal status under Tennessee law. And even under what the officer reasonably believed, that he was 17, it was likely that he would not be transferred to the adult courts under the statutes in effect in 1974, but would have similarly been consigned only to the juvenile courts.
Bodies, and he was identified as the killer, what would have been the maximum penalty?
If he had been committed murder, then he could have been treated as an adult at that time. But the Tennessee statute, which is 37-234, specifically provides that juveniles less than 16 at that time could only be bound over for violent crimes. And it specifically excluded burglary as one of those crimes for which a 15-year-old could be bound over to the adult courts. So the answer to Your Honor's question, he could have been treated as an adult for murder, but not for the burglary that he in fact committed.
Mr. Winter, this was an action for damages, was it not?
Correct.
And the state asserted the statute as a defense. As I read the Court of Appeals opinion, it declares the statute perhaps facially invalid. Is that your reading of it too?
Well, I'm not quite certain, Your Honor.
Hold on one second, guys. I'm so sorry. Give me 15 seconds here. Okay, got it. Sorry about that.
I understand the operative language to be found at A44 of the appendix, where the court at the outset of its analysis states, the narrow question presented is whether a state law authorizing the killing of an unarmed, nonviolent fleeing felon by police in order to prevent escape constitutes an unreasonable seizure of the person.
Well, that doesn't strike me as a very happy phrasing of any question. I had never known before that a law could constitute an unreasonable seizure.
Well, there are problems with the court's formulation, I would agree, but I think the essential import of what the court was saying is clear, and that is that, as applied to these facts, certainly, where the officer testified that he knew the juvenile to be unarmed, that the shooting under these circumstances is unconstitutional.
Well, you would agree then that if the Court of Appeals opinion goes any further than to say that on these facts the Tennessee defense statute can't be applied, the Court of Appeals is wrong.
I would say that this court need go no further than to affirm the judgment below on these facts.
God.
So we're talking about an as-applied basis, not a on its face basis.
Yes. The other aspect, I wanted the court should also be clear about the facts that my opponents neglected to mention, and that is that the district court made an explicit finding, which is also found at A4 in the appendix.
Are we good, guys? Is everybody good? Can you guys see everything? So sorry. Let me make sure we're still good here. Okay, are we live again? Are we back? Are we good, guys? Give me a number one if we're good. Is everybody back online? Is everybody back online? Is everybody back online? Oh, Lord. Let me see. Are we on? Oh, I hope it didn't go. Oh, Lord. Black screen, but audio. Damn. Can you guys hear me? Let me